let us start to solve the questions of Indian Evidence Act. First of all, we read the quotation. आज मुश्किल है, आज परेशानियां हैं, पर कल बेहतर होगा। ये क्या है? होप, वी होप। बस तुम उम्मीद मत छोड़ना, आशा बनाए रखना। एक चांस, दो चांस हम अपीयर हुए, we appeared in the examination of PCSJ, but we failed. Next time we will succeed. This is the hope, and on this hope we continue my work hard. Yes, you start up. You start. Get up. And continue your hard work. That's all. In this class, I have taught you 4 questions. Question number 5. Question number 5, I start. A is prosecuted. A is prosecuted for the murder of B. The prosecution adduces various evidence regarding A. Of his previous bad character, of his previous bad character, the evidence is admissible against A. No. Previous bad character is not admissible. Is not admissible because evidence must be produced relating to the case, relating to the incidents, but evidence of bad character should not be produced. It shall be inadmissible. So the correct answer of the question is B, is not admissible against A. Question number 5. Next question, assertion. In criminal cases, the fact that accused is of good character is relevant. In criminal cases, the fact that accused is of good character is relevant. Yes. Section 53 says that in criminal cases, character of, it means good character, may be produced as an evidence. It shall be relevant. So assertion is true, yes, but in criminal cases, bad character of the accused is always irrelevant. Undoubtedly, bad character according to section 54 is irrelevant, but under special circumstances it shall be relevant. What the circumstances? If evidence of good character is produced in criminal cases to contradict that bad character may be produced as an evidence. So, the correct answer of the question is C. A is true, but R is false. Next question. A is accused of the murder of B by beating him. Yes, it means A beats to death B. A beats to death B. What is not admissible as evidence? First, whatever was said by A or B bystanders at the time of beating, yes, it is relevant. A has intention for murder of B, yes. Marks on the ground under section 7 is also relevant, but A is a man of bad character is not relevant, so is not admissible. So the correct answer of the question D. Correct answer of the question D. Okay, D shall be correct answer. Character as affecting damages. Character as affecting damages has been discussed in which one of the following sections? Character as affecting damages. Undoubtedly, in civil case, character should not be produced as an evidence, whether the character is good or bad. Neither type of character shall be produced as an evidence. But in civil case, section 55 says, if there is a problem to determine the amount of the damages, character may be produced as an evidence. Section 55 says that. It means where in case of determining the amount of the damages, evidence of character may be produced. Section 55 says that. So Section 55 of Indian Evidence Act 1872, it says that, it discusses to determine the amount of damages, evidence of character may be produced. So the correct answer of the question is A. Evidence of character includes evidence of, it means evidence of character includes what? Only disposition, reputation only, general reputation and general disposition, it means the both. Particular acts by which reputation or disposition were shown, particular acts. Evidence of character includes disposition and reputation, the both. The both shall be relevant. It means evidence of character includes reputation and disposition, the both. So the correct answer shall be C. Here, general reputation, general disposition, the both is included. So evidence of character includes reputation and disposition. So answer of question 9, option C shall be true. Next question. The term judicial notice, the term judicial notice under Indian Evidence Act 1872 means notice given by the court, information given to the court to ask for evidence, to recognize without proof something unexisting. It means the term judicial notice means it requires no evidence. It requires no evidence. So the correct answer of the question shall be D, because here it shall be recognized, judicial notice shall be recognized without any proof. It means no evidences are required. No evidences are required. So the correct answer of the question 10, D. Which of the following is required to be proved? Essentially, judicial notice, section 56. Section 56 says that judicial notice does not require to be proved. So A. Next, admitted fact. Yes, admitted fact is also not required to be proved. It means it shall be accepted as an evidence. No need of to be proved. So this is also not required. Confession, parties accept any offense, that also need not require to be proved. These three options A, B, C need not require to be proved, but relevant fact, that is option D, needs required to be proved, because relevant fact requires proof. So the option D is the correct answer of the question 11. Next, the facts by the parties which do not need to be proved include. The facts by the parties which do not need to be proved include the fact in respect which the judicial notice is made. Yes, not need to be proved. Fact accepted by the parties at or before the hearing. Yes, it is also not required to be proved. A or B? No. Both A and B? Yes. Option D shall be the correct answer of question 12. Because in both cases, whether the judicial notice or any acceptance made by the parties shall not be required to be proved. So the correct answer of the question 12 shall be D. Okay. Next question. Which of the following facts are required to be proved? Which of the following facts are required to be proved? Are laws in force in the territory of India? Yes. Public festivals and holidays notified in official gazette? Yes. The rules of the road? Yes. None of the above. Here the question. Which of the following facts are required to be proved? These three, it means in option A, B and C. Whatever the facts are mentioned need not required to be proved. Need not required to be proved. So the correct answer of the question shall be D. It means no proof is required in case of option A, B, C, but D, above none, none of above. So the option D of the question 13 is correct answer. Next, court shall not take judicial notice of the following. Court shall not take judicial notice. In which case court shall not take judicial notice? Name of the officer and member of the court? Yes. The fact that is in the personal knowledge of a judge of a court, of a judge of a court, it is the fact that is in the personal knowledge of a judge of a court. Here, personal knowledge of the judge, it is not a subject of judicial notice. It is not a subject of judicial notice because under section 57 of Indian Evidence Act, those facts are mentioned under which need not required to be proved. So the correct answer of the question B, because it is a personal knowledge of a judge of a court. The court shall not take judicial notice of the following. The fact that is in the personal knowledge of a judge of a court. This is the correct answer of the question. Okay? Yes. Next question. Under Evidence Act, which of the following facts need not to be proved? Which of the following facts need not to be proved? What is the correct answer? Under Evidence Act, which of the following facts need not to be proved? all laws in force in India. Yes. All public acts. Yes. Proceedings of parliament and legislature, assemblies of the act. Yes. All of them need not required, need not be proved. These facts A, B, C options, any facts are mentioned, those facts are mentioned, need not required to be proved. So all of them is the correct answer of the question 15. Okay. Next. Which of the following facts need not be proved? Fact which is not admitted, fact which is judicially noticeable. If any fact is admitted, need not required to be proved. But if not admitted, then requires to be proved. Here, not admitted, the term not is used. It requires to be proved. The question is, which of the following facts need not to be proved, not be proved? It requires proof, so it is wrong. Fact which is judicially noticeable, yes, need not required to be proved. Fact which is subject matter of a document, which is a subject matter of a document. Fact which is disputed. Question is not be proved. The A, C and D. Option A, C and D facts are mentioned, need, require to be proved. But in option B, need not required to be proved. Need not required to be proved in option B. Okay, so the correct answer of the question B. In which act the facts of which judicial notice is to be taken are stated in? In which act the facts of which judicial notice is to be taken are stated in? Judicial notice undoubtedly defined in section 56, but what are those facts on which judicial notice is taken? The facts, the subjects are mentioned in the section 57 of Indian Evidence Act. So here the question is, in which act the facts of which judicial notice is to be taken are stated in section 57? Yes. So the answer of the question is section 57. Next. Which of the following facts cannot be subject to judicial notice? Under following options, facts are mentioned, but which fact which facts cannot be subject to judicial notice? Common law of Britain, it is a foreign law. Foreign law. Foreign law requires to be proved. It is not, it shall not be taken as a judicial notice by the court. It means it requires to be proved. Why? Because it is not enforceable in India. It is a foreign law. So the correct answer of the question is A. Why? Because which of the following facts cannot be subject to judicial notice? If the subject is, if any fact is a subject of judicial notice, it means that subject, that fact need not require to be proved. Common law of Britain is a foreign law. It is not enforceable in India. So it shall not be taken, it shall not be subject to judicial notice. And the correct answer of the question 18 shall be option A. A is the correct answer. Which of the following case is related with judicial notice under the Indian Evidence Act? Yes, the correct answer of the question Hari Shankar Jain versus Sonia Gandhi. This is the correct answer. Yes. Okay, thank you for watching.